All right. Thank you, everyone, for waiting. I think we're about at critical mass, and so we'll get this started. Miles, are you on the line?
I am.
Excellent. Thank you. I'll turn it over to you to get started.
Great. Thank you, Jim, for all the work that you've done to pull this together. And thank you particularly to Mike Bailey, Jason Castor, and Thomas Beckett with Parsons, Behle Latimer for joining us today. And thank you to everybody who's logged in. We know that it's unprecedented times that we're living in right now. And so we're grateful that you would take time out of your day to hear from these legal experts about how you can address contract issues as we all work through these challenging times. You know, thank you to everyone who's new with our webinar series, and thank you to those who tuned in yesterday. For those that weren't there, just for your awareness, we are planning a series of webinars to help make sure that Utah companies are connected with the resources that they need to address the challenges that we're all facing right now. So yesterday, we had legal experts located in Beijing that provided the view from China. If that would be interesting to you, you can find a recording of that webinar on our YouTube channel. And then, of course, today we're talking contracts. You know, before we jump in, just a couple housekeeping points. Throughout today's presentation, you'll see a chat box on the right side of your screen. Feel free to type some questions. If you have any questions at any point, go ahead and enter those in the chat box. We will then have a moderated Q&A session at the end of the panel. And when we finish today, you all should receive a survey. Please take 2 or 3 minutes to provide some feedback. These webinars are new to us. We want to make sure that both on the logistical side and the substantive side, that we are very effective in delivering this substance and expertise to you. So please let us know what worked well, what didn't work well, and then also let us know what topics would be most helpful to you in your business. We want to make sure that we are calibrating everything that we do as an organization to make sure that we're able to add value to you and your business. Before handing it over to Jason, let's just take a quick step back. So, of course, many of you are familiar with World Trade Center Utah. We want to make sure that we are helping all of you as we try to figure out what to do with the concerns we have over our health, over the economy, and here in Utah, even earthquakes. It kind of reminds me of lions and tigers and bears, oh my. And there definitely is a sense of oh my this week. If we take a step back for a second, what does that mean? What are we doing as an organization? We've been looking at what the state of Utah did the last time we had these significant economic headwinds, in 2008, 2009, and 2010. I'm serving on the governor's economic task force, and we've asked ourselves a lot, what did we do then? What could we have done better? What lessons can we learn? And what's unique to this situation? And it's interesting to note that Governor Herbert came into office in 2009. In 2010, in the depths of the Great Recession, the economy was bottoming out. He came up with his economic plan. There were 4 key priority areas. International trade and investment was one of the 4, so it was a top priority. And so as a state, we focused in significantly on helping Utah's economy become even more international, and to use that as a significant driver of economic growth to pull us out of the Great Recession. With that focus, it's interesting to note that exports from the state of Utah doubled from 2009 to 2012, and that pace continued all the way up even in the past couple of years. The growth rate of exports from Utah has been the highest in the country over the past 2 years. Utah's economy is very international in nature. Of course, 1 in 4 jobs is supported by international trade here in the state. And yet, in this particular crisis, we're all familiar with the fact that a movement of people and goods is severely limited because of the public health responses to COVID-19, which is causing us to say, okay, we know that international trade and investment is so important to Utah's economy. We know that right now we are facing unprecedented challenges to engaging in international trade and investment. So as an organization, what do we do about that? How do we help companies? What we are doing is recalibrating our programs to help companies adjust to these challenges. So first off are grants. Many of you are familiar with our grant programs. They're designed to help companies increase their international sales. What we're doing now is saying, you know what, companies are facing unprecedented challenges and problems. Let's make sure our grant funding is available and accessible to Utah companies to help them find solutions to their problems. And so we're focusing in on making sure that we can get some flexibility in our grant requirements and programs so that as companies are facing problems with contracts being canceled or trying to enforce a contract, as they have manufacturing that they rely on going offline, they need to find other people. If they're looking to shift more to e-commerce, website optimization, as they're looking to pay for consulting services to help them identify how they should adjust to this challenge, we want to make sure we have sufficient grant resources for Utah companies, small businesses, so they can adapt, innovate, and overcome the challenges they're facing. We also are leaning into our consulting services that are free for companies, our market research, and then also I want to highlight in particular our business-to-business matchmaking. So as you think about your companies, if you're doing business in China and you need to find somebody else, maybe it is a financial institution there that can help you with issues. Maybe it's local law enforcement to help you with contract issues in China. Maybe it's looking for a new manufacturer or a new distributor. Please let us know. We want to leverage our global network to open doors and generate momentum for our companies and help them connect with the right people anywhere in the world to help them solve their problems. And then another key thing we're doing is this webinar series. So we can't gather together in person, but we are committed to make sure on a regular basis that we are able to bring in experts that can help deliver insight, a subset of information to you to help reduce a little bit, at least, the uncertainty that we're all facing. And that's why we're so grateful for Parsons Behle and Latimer for being with us today, Jason, Mike, and Thomas for your willingness to share your expertise with our companies. And so with that, Jason, I'll pass it over to you. I understand you've got some introductory remarks, and then we can go from there. So Jason, over to you.
Great, Miles. Excuse me. Thank you very much for the great introduction and for all the great work that World Trade Center Utah is doing to help people in the state of Utah and beyond address the COVID-19 pandemic and crisis. As Miles said, thank you very much to all of you for joining us this morning. My name is Jason Castor. I'm the Director of Business Development and Marketing for the law firm of Parsons Behle Latimer. And I just want to start off by saying, on behalf of World Trade Center Utah and Parsons Behle, we wish you and your families and your colleagues the best of health, stay safe, and be well during these difficult times. We're all in this together, and we want to be a resource to each and every one of you and to your businesses. Miles, thanks again to you and your team at World Trade Center Utah for the partnership with Parsons Behle Latimer. It's a partnership that we value very much, and we're thrilled to be a part of your webinar series. As we move into the agenda and into our program today, I want to introduce my two colleagues. Joining me are Mike Bailey. Mike is a senior litigator in the firm's litigation department at Parsons Behle Latimer, and it also serves as a member of the board of directors for World Trade Center Utah. And Tom Beckett, who is going to be leading today's webinar, oversees the firm's insolvency, restructuring, and workout practice, and has a great deal of experience related to force majeure clauses with respect to contracts and business interruption. So I am now going to turn the time over to Tom as he leads us through this webinar. As Miles indicated, we will use the chat feature with questions throughout the webinar, and then when Tom concludes, we can open up the mics, and if people would like to ask questions live, we can do that as well. So, Tom, with that, I'll turn the time over to you, and thanks again to everybody for joining us this morning.
Thank you, Miles, and thank you, Jason. Good morning, everyone. Thank you for joining. It's the first day of spring, and I hope you're all well. In the past 3 weeks, I've gotten a lot of questions about force majeure. Most of them are about businesses that want to know how to approach negotiations with counterparties, given the specific force majeure clauses in their contracts. So that's what I intend to focus on. I've also received, happily, some questions about how to write new force majeure clauses for new contracts, and I'll briefly touch on that. Now, you may be attending because you have other questions, Please use the chat function to state those questions. Mike will be monitoring that for me, and we'll address those during the presentation or afterwards. I intend to be brief. I think this will take 20 minutes, give or take. I don't think force majeure is difficult to explain. I do understand that people have questions about it because it is a contract provision that is shrouded in mysticism. Right now, we have lots of contracts. You have lots of contracts and contractual relationships that are under deep stress, with more than one party having non-performance, which is imminent. Some of these relationships may eventually fall apart, and the result will be litigation and bankruptcy, but that's not the preferred course right now. For, among other things, the courts are closed. For the time being, it appears to me that businesses are monitoring and assessing the situation, and I hope planning to renegotiate terms with counterparties and get back to business after the health risk and its economic shock have been sufficiently addressed. In those negotiations, you will know the business terms, but it is a legal issue that may be the elephant in the room, and that's force majeure. For force majeure determines who owes whom how much money in the worst case scenario when the wheels come off. And right now, because of COVID-19, the wheels are coming off. And so this little known provision in contracts is going to become very important. Discussing the force majeure clause will be part of your negotiations. So what I want to do is try and demystify those clauses for you. I'll explain them. I'll walk you through the language of a couple of them so that you can see how they work. And ultimately, I hope to help you become sufficiently familiar with them so that they're not the elephant in the room. So what's the purpose of the force majeure clause? What are the topics that I'm going to cover to familiarize you with them? First, what's the purpose? Why do we care? And then I'd like to tell you a story about one particular force majeure clause that Mike and I litigated some years ago. I want you to consider it as an important case study on why not to get this analysis wrong. I'm going to show you another force majeure clause that's very similar, but because of a slight difference, has a very different effect. And I'll conclude with some pointers, and then, time permitting, we will have questions. I want to make a preliminary comment about force majeure clauses. They're very unfamiliar to non-lawyers. And force majeure is French for superior force, but you don't need an expert on European common law to understand them. They do not have deep hidden meaning. The common law on force majeure and impossibility and concepts like that is murky, but if your contract includes a force majeure clause, then the common law is not relevant. Courts will look to what you meant, not what the common law says. And if you only have one takeaway from this presentation, I hope it's this. Force majeure contracts are contract provisions. Force majeure clauses are contract provisions, just like any other contract provision. They will be enforced by the words in the contract. So what's the purpose? Jason's next slide. Okay, here's the analysis. And here it's a problem, a question, and an answer. The problem is that sometimes a party can't perform under a contract because of circumstances beyond its control. For example, because of COVID-19 and the economic shock. And this raises a question. Is the non-performing party liable for damages? Or is it immune from liability because its non-performance is somehow excused? In other words, how did the parties agree in the contract to allocate the risk of loss attributable to disasters that are out of their control? And the answer again is, it depends on what the contract says. Now I want to tell you a story. Next slide, Jason. Deloitte Consulting had booked every room in a 5-star hotel in Salt Lake City to hold 2 week-long celebrations of the achievements of its very best employees. These celebrations were scheduled for late September 2001. But after 9/11, Deloitte canceled both events. Now, let me tell you the backstory. In the year 2000, Deloitte had something like 145,000 employees worldwide. They were arranged by classes. They had junior managers, senior managers, etc. And once a year, the cream of the crop of each class was moved up a notch. To celebrate their accomplishment, Deloitte would fly them to high-end hotels and resorts all over the world and wine and dine them for 4 or 5 days. Deloitte did so many of these events that they had a staff of 20 full-time event planners. And Deloitte was so large that it had these events going on almost constantly. Deloitte's professionals are management consultants. They live on airplanes. 2 days after 9/11, Deloitte had over 1,000 professionals that were still accounted for. The next day, 3 days after 9/11, they canceled all of their celebratory events for 4 months. Nearly all of the affected resorts and hotels returned Deloitte's deposits immediately with notes of deep sympathy. We're sorry for your loss, so please remember us if you're ever back in Boca Raton. One hotel did not. That hotel took the position that 9/11 was not a force majeure event, and Deloitte was liable for damages, and they filed a lawsuit. The case went to trial, and I'll tell you how the trial ended in a few minutes, but first I want to walk you through the force majeure clause of that contract, and we're going to slog through it, and you can decide how you think the trial ended on the basis of the language of the contract. In the next slide. The analysis here, in particular, is that Deloitte did not perform because of 9/11, an event that was out of its control. That raises the question, was it liable for damages? That was the question in the lawsuit. And the answer, it depends on what the contract says. Next slide. Here's the force majeure clause. It's way too much to absorb. Let's break it up into pieces. Next slide. It begins, a failure of either party to perform its obligations under this agreement shall not constitute default under this agreement or give rise to any claim for damages. Okay, so in other words, Deloitte's cancellation might not result in liability for damages if certain conditions are met. If and to the extent such failure is caused by occurrences, whether direct or indirect, reasonably beyond the control of the party affected. Now, obviously, 9/11 was beyond Deloitte's control. Almost all contract clauses, the force majeure clauses, have a for example list. And here you have including but not limited to. These lists are illustrative. They're not exclusive. But they tell you what the parties were thinking of when they said that there would be occurrences that would excuse non-performance. Let's just look at these. First, with respect to acts of God, if you rely on acts of God in a court of law, you will find that most judges will say, I'm not going to decide that. It's rather above my pay grade. The other provisions are a little easier to understand. War, government regulations, disaster strikes, disorder, curtailment of transportation facilities, or other emergency. How many of these do you think apply to 9/11? Certainly disaster, curtailment of transportation facilities, and other emergency. Next slide, please. So far, working through this, I think you probably suspect that 9/11 was a force majeure event that excused performance by Deloitte. But there's one more test. The occurrence, nope, go back one. The occurrence had to have made the agreement inadvisable, illegal or if it is impossible to provide the facility or hold the event. Now, would it have been illegal to party in Utah shortly after 9/11? No. Would it have been impossible? It's a difficult question, but probably not. Was it inadvisable? It certainly was inadvisable. It was inadvisable for Deloitte to instruct several hundred of its top employees to get back on airplanes, go party in Utah while they were all still in shock. And that's what the judge decided in this case. He held that 9/11 was an emergency, that it was beyond Deloitte's control, and Deloitte decided in good faith to cancel the event because it was inadvisable. So Deloitte was excused of its non-performance and had to pay nothing in damages. Now, the hotel, on the other hand, didn't have to pay damages. They had filed the lawsuit, but they were pretty much blacklisted from large corporate gatherings for several years. And there's a lesson in that the performing party, the other than non-performing party who insists on application of the force majeure clause may face consequences for taking that part position. Yeah. Next slide, please, Jason. So let's look at a second force majeure clause. It's very similar. We can run through it quite quickly. It's structurally similar, but different in effect. Let's break it up into pieces. Next slide. The performance of this agreement is subject to termination without liability upon the occurrence of any circumstance beyond the control of either party. We've seen that. Next slide. Such as, again, you have a list of similar situations, acts of God. You see now this this is a post 9/11 force majeure clause, so now it has the act of terrorism included in this illustrative list, and we can expect to see force majeure clauses drafted going forward will include the word pandemic in this list. Next slide, please. Again, there's one more condition. This is the last condition and most important. To the extent that such circumstances make it illegal or impossible for the hotel to provide or for groups in general to use the hotel facilities. Note that the word inadvisable is not here. The parties did not agree to insert that or include that word in their contract. Now, think about Deloitte. Think about the circumstances that gave rise to Deloitte. 9/11, would it have been illegal or impossible for the hotel to provide or for groups in general to use the hotel facilities? It would have been a much more difficult case than the one Mike Behle and I did some years ago for Deloitte. It would have been much more difficult with this clause because it doesn't include the word inadvisable. It would have been more difficult for us to prevail in that litigation. The point is, again, the force majeure clause is not mysterious. There's no deep hidden meaning. The courts will enforce it according to its terms. And this clause, although structurally similar, has a very different effect than the one we looked at for Deloitte.
Hey, Tom, this is Jason. Pardon my interruption. Could you lean into your mic a little bit? You're cutting out.
They're in my ears, so I don't know if I can do that.
Okay.
I'm going to try and figure out if I can. Has it been really bad? Okay, let's go to the next slide. I'll try not to move. The two examples I've used are about event cancellations, but the point is most commercial agreements, not just event agreements, include force majeure clauses. Some financial agreements do, but not loan agreements. There's really no excuse for not repaying a loan. Next slide. So what do we expect? What can you do to modify a force majeure clause, or what can you do in the negotiation of a new force majeure clause going forward? In the for example clause, we're going to add pandemic, epidemic, or contagion for sure. You can add tests or circuit breakers to force majeure clauses. I've included one example. In no event shall the circumstance be a force majeure event unless there is a 30% reduction of confirmations for the event 2 weeks before the event compared to an average, and so forth and so on. So you can modify those terms, add tests and circuit breakers. And you can also have carve-outs. One example that appears in some cases is a general downturn in the economy not attributable to any of the foregoing force majeure events is not a force majeure event. Okay. If you are a buyer, you may want additional protections. You might want to say if the seller can't manufacture widgets, then the buyer can purchase them from someone else, or after a force majeure event, seller agrees to resume manufacturing with ultimate burden speed. Okay, next slide. There's no deep hidden meaning in force majeure events. They're going to be enforced according to their terms. Now, most of them have time limits, so you need to look at them. You have to give notice of impending non-performance within sometimes 10, sometimes 15, 30, even 45 days after the event of force majeure. I don't know what the event of force majeure is in connection with the COVID-19. It could be the declaration of an emergency. It could be a stay-at-home order, which would make convening for a conference illegal, as well as impossible and inadvisable. Read them carefully and understand them so that you can negotiate with the counterparty and avoid non-performance. Right now, we're reacting to an emergency. We're trying to maintain contractual relationships and supply chains because when we get through this, and we will, then we want to pick back up as seamlessly as possible. Litigation is not a good option right now. But as you negotiate the terms or renegotiate the terms for your relationship going forward, in that negotiation, you're going to have to address force majeure. What I hope is that if you understand it, it will not be the elephant in the room, which discourages the mediation and negotiation of a new contract going forward and maintains the relationships. Next slide. Thank you. I hope that short presentation gives you some idea of what you're dealing with force majeure clauses. I'm happy to entertain any questions that you have.
Hey, Jim, at this time, if we could open up the participants' microphones, we'd be happy to let people ask questions to Tom right now.
And Tom, this is Mike. We have a very good question. Can you hear me okay?
Yes.
So we have a good question. When is the best time to reach out and invoke a force majeure clause when you're trying to be excused from performance? Is it when the crisis occurs or as you approach the milestones that are going to be missed?
In a situation like this, Mike, I would suggest that the sooner the better, because you want to explain to the counterparty what the occurrences are, what the events are that make it impossible for you to perform going forward. Even if it's just a warning, I may not be able to perform. I'd encourage people to open that channel of communication as soon as possible. Is that responsive?
Yes, thank you.
Hello, everyone. Let me jump in here. Most people should be able to talk now. If you're not able to talk, you will be here in just a few seconds.
Tom, this is Mike. Let me just kind of pose one other scenario, and that is, you know that the Grand America case that you primarily tried, I assisted a little bit, and you did a fantastic job. I'm not sure you actually took the people listening through the ultimate decision in that case, but maybe you could kind of talk a little bit more about how the judge ruled and why the judge ruled. But the other thing is we have a lot of people on the line today. You know, some are looking to have their performance excused. Of course, some are looking to, you know, in the situation where they're going to have others that any day are going to contact them and try to get their performance excused. So do you have any advice for the people on the line that have contracted with people and there's a force majeure clause that might be invoked against them?
Yeah, with respect to the court's decision, I hope it wasn't that my earbuds blanked out at that moment, but the court looked at the illustrative. Can you hear me?
Yeah.
The court looked at the illustrative list and found that the 9/11 was, although terrorism was not listed, 9/11 was an emergency, and so it fit within the definition. And he held that Deloitte had decided in good faith to cancel the event because it had determined, and if I recall correctly, the judge applied a subjective test. He was convinced by the testimony of the people at Deloitte that they had determined in good faith that it was inadvisable to hold the event. Whatever side, and thank you for the next part of the question. I think this is important. I want to reiterate on the next, whatever side of the force majeure contract provision you're on, whether you are the non-performing party or the other party, I think the analysis is the same. I think the analysis is that you're going to have to pull out that old contract and dust it off and study the force majeure clause, because it's going to be an important point in the negotiation. These clauses are, invite argument on both sides. One side can say adamantly, this is not a force majeure event. The other side can read the same words and say, well, it certainly is. And the point is that in that negotiation, you want to understand that clause well enough so that you can make your point, understand the other side's point, try and reach some common assessment of the risk of loss, because that's an important point of the negotiation, and then move on. So I think I would say whatever side of the force majeure clause you're on, non-performing or other, you need to understand it so that you can address it in the negotiation, get through it, and then get to the important points, the business terms that you want to have with the counterparty after the crisis is over.
Tom, can you hear this question?
So far I can well, thank you.
In our current situation, no one really knows the action of government in the next 30 days or 60 days or maybe 90 days. What is a reasonable time frame when you're in the middle of trying to negotiate a final contract? You want to go forward with it, but there is so much unknown because of the current pandemic and the action of government.
That's a really excellent point, and thank you. You know what you want, you know what the other side can provide. You don't know what the backdrop is, and that is government action. And it's also, I think there were no new cases in China yesterday. and that's a good sign. 4 months, and maybe there will be certainty after 4 months. I shouldn't have used the word certainty. You may not be able to proceed until there is sufficient economic certainty to understand what a contract looks like, because you don't want to enter into it until both parties believe they can perform going forward. At this point, it's hard to understand if any of us can perform in a contract going forward until there is some certainty. In the meantime, if you have a conversation with the counterparty and they're in as much confusion as we are, which is likely, then I'd recommend a forbearance agreement, and you say, we're just going to kick this can down the road for a month, and then we'll readdress it, or 2 months, and we'll readdress it when we know what we need to do.
Thank you.
Tom, this is Mike. A question is coming in through the chat function. If your clause does not have a carve-out for general economic downturn, are courts normally willing to consider an economic downturn a force majeure event?
If it is caused by what is listed in the, for example, then yes. If in 2008, we had an economic crisis caused by the bundling of mortgages, right? That those bundles fell apart and the economy fell apart, and we didn't see those being force majeure events unless the contract was pretty specific about economic downturn. Now, in 9/11, we had an economic crisis, but it was caused by an act of terrorism. And an act of terrorism looked like the kind of crisis that was in most, for example, provisions of force majeure contracts, and the courts enforced them according to their terms. Even if the cause of the non-performance was economic, the cause of the economic crisis was the act of terrorism. And you'll recall in that provision that we had in that litigation, Mike, and I couldn't have done it without you, it referred to consequences that were directly or indirectly caused by, and then the for example list, in as much as the economic component of the failure to perform was at least indirectly caused by the act of terrorism, then the non-performance qualified for immunity from liability. Any other questions?
Yes, so we've got another question on the chat room. In terms of a rental agreement, whether commercial or residential, and I think the person writing in is kind of looking for a general answer. Could the renter get out of the lease/contract by invoking a force majeure clause if it's in there? And then the second question is, if the lease has no force majeure clause, do you think that courts might read one into an agreement where one does not exist?
The first part of your question I can answer by saying simply you've got to read the provision in the contract. If there is a force majeure provision, it may have the word advisable, it may not have the word inadvisable. In rental contracts, these are rare. Landlords expect tenants to perform, but that may be in there and you're going to have to read it. If there is not a force majeure clause, then the court will resort to common law concepts like force majeure, but that's mostly been subsumed within the concept of impossibility. It is impossible for me to pay my rent. That's a tough road to hoe.
Thank you.
Let me say I've never seen a case where the payor, as opposed to the seller, the payor in a contract has been able to be excused of performance because of a general economic downturn, creating an impossibility due to cash flow. And if there are any other on the, Mike, I can't see the chat box, so if there are any other questions you have.
Yeah, we have another question, and then after you answer this one, I think I'll leave the mic open just for a second and see if anybody wants to ask a question live. But here's the latest question on the chat function. If your contract does not include a force majeure provision, are there other common clauses such as frustration of purpose that could be used to the same effect?
There may be other clauses in the contract that address circumstances like this, other than the force majeure clause. The concepts of frustration of purpose and impossibility and force majeure itself is a common law concept. Yes, those come into play by virtue of the common law. Was that responsive?
Yes, thank you.
Mike, can you see the next one? I could only see 2 lines of it.
Yes, let me read it directly. Does a force majeure clause that does not directly address payment of fees relieve a customer from payment for services that have already been delivered before the force majeure event? Great question.
So Mike, help me out here. You put it in a hypothetical, will you?
Well, yeah, so you have a client that, that has already received the services, but now they've not paid the fees. And so what does the force majeure clause do? You know, like for instance, what if Deloitte had already utilized the hotel? And now the question is, do they now have to pay the fees for the services that have already been delivered?
In fact, this came up yesterday where people had, I was asked about a case where a lot of people had paid deposits for travel internationally over the summer. And I think talking about it, our thought process went like this. If those people understood that they were making a down payment to make possible the exploration of an international trip, they were in effect, you know, investing seed money in a project to be consummated later. If they understood that everything was already in line and they were just paying a deposit to hold their place so that they could go internationally on this travel, then I think that a full refund is probably what's required by the law. And I would think in most circumstances, like the one you said, if Deloitte had its party at the Grand America Hotel, and for some reason Grand America had given them 90-day terms, and within the 90 days there was an attack on the World Trade Center, and Deloitte said, "My pockets are empty, I can't pay." Again, the responsibility to pay is pretty much required, and very few excuses. I think what the law considers the way to avoid having to pay for a service or already given or goods already delivered is you need to file bankruptcy.
Thank you, Tom. Tom, do you, we have a viewer who wants to talk about force majeure clauses in terms of earthquakes. I can't imagine why. For example, rent for a building that might be deemed inhabitable.
Oh, that's really good. I'm looking back at, you know, I don't know. Again, is this an act of God? Is it a disaster? Yeah. Is it another emergency? Yeah. But again, and some force majeure clauses say either party may invoke this clause. Some of them say only the seller, the one who manufactures and sells the widgets, the goods, or the one who provides the services, can invoke the force majeure clause. It is always harder to avoid paying. Now, you know, your lease, it says I'm going to pay you $100 a month, and I expect to live in a habitable building. And I think that you can probably read the purpose of the agreement that way. And when the landlord says, "Where's my rent?" the proper response is, "Where's my habitable building?" If they're not providing what the contract proposed that obligated them to provide, then the other party has no obligation to make the payment.
Tom, if I'm kind of getting one message, and maybe this isn't the primary message that you're trying to get across, but if I get one message from all this, it's that, you know, although we all use the term force majeure like all clauses are the same, they're not all the same. They're dramatically different. Commas here or there, or lists, or one word could dramatically change how a court would look at a clause.
As I said in the beginning, if there's one takeaway, it is that, and Mike, you're right. You know, the idea of force majeure, that refers to common law. It also refers to terms in a contract. If you have what we call force majeure provision in your contract, then the common law is irrelevant, and only the words of the contract apply. And you're quite right. You're going to have to live with where you put that comma when you signed the agreement 5 years ago. You may not have reflected on what a pandemic would mean given that comma, but right now you are going to have to live with it. But as I say, you know, the inclusion of words like directly or indirectly, and in the second contract we saw the phrase "to the extent that." These provisions can look like they're heavily weighted for the non-performing party, usually the seller or the other party, but there is always argument to be made on either side. And again, in these circumstances, what we're doing is trying to get over this hurdle and moving on to a discussion and negotiation of business terms, which, when we have certainty where the markets are going and where the health of the world is, then we can maintain those contractual relationships, maintain those supply chains, and get back to business. And so again, yeah, read the terms of the contract, understand it in your mind, argue both sides of it, argue it with the counterparty, move on, and we're recommending that you get back to business, not that you try to run to court to litigate your force majeure clause.
Tom, we don't have any additional questions, but I wonder if you could just take a minute and talk about the duty to mitigate. And in light of the duty to mitigate, or whether that's in the contract as well, and I know that that is often a contract provision that may or may not be in the contract also, but I'm wondering whether force majeure clauses, and it may just be the language of the clause, but whether force majeure clauses are all or nothing propositions. Like, for instance, in the hotel case that you talked about, if Deloitte's employees had all been in Salt Lake City and the hotel was in Salt Lake City, how would the argument have come out if the hotel had argued, well, nobody needs to get on a plane, nobody needs to leave their home, you can still have the event? Or in the situation now where the CDC has recommended that we don't have groups gathering of over 10, might you still have to do something if the party you contracted with can figure out how to conduct the event in a way that would be safe under the CDC guidelines? I know there's a lot packed in that question, but I'm just wondering if force majeure issues are generally all or nothing type propositions.
I would begin with the presumption that they are all or nothing unless they say otherwise. It's not uncommon for a force majeure clause to include a duty of mitigation. I'm not sure there's no such duty in the event that that carve-out is not in the contract. I think there probably is a duty of mitigation. And what you see in the negotiations is that the party who cannot attend the event, for example, Deloitte, goes to the hotel and says, yeah, no, we're not going to be here in the next 3 weeks, but I tell you what, we'll sign a contract that guarantees that we'll come back next year and the year after. We won't chop this. We won't go to your competitor. We will give you the business for the next 3 years. And that's usually an accommodation, or that's often an accommodation sufficient to get the negotiation done. The other side is also should be thinking, in the case of the hotel, if I insist on enforcing the force majeure clause, I may give myself a black eye in the industry and have no corporate parties at my hotel for the next few years. With respect to your question about what if everyone were in Salt Lake City, I mean, this is what judges and juries do, is say, well, now it's not illegal. And I don't know if the CDC or if the Utah Department of Health also yesterday said no gatherings of more than 10 people. I don't know if that makes it illegal yet. When you have a proclamation which allows the police, as they are in Italy, to arrest people or fine them for violating that prohibition, then it is certainly illegal. What you're asking is it impossible? Happily in that contract, I think the ultimate result would have been the same, because recall that Deloitte had said, we lost people in 9/11, our clients lost people in 9/11. It is inappropriate and therefore inadvisable to have a party, even if everyone lives within 20 minutes of the Grand America Hotel. So again, and that's why I took you through some of the facts of the case for Deloitte, is that's what you have to do. That's what judges and juries are going to do. You have to consider the facts of the case, and you have to consider the language, and it's the business people who are going to tell the lawyers, oh no, it is impossible, and let me explain to you why. Did that capture?
Yes. Yeah, I asked a lot of questions, Tom, and you actually answered all of them.
Oh, good. Anyone else? I hope this has shed some light on the issue.
This has been fantastic. Thank you very much, Tom. And thank you, Jason and Mike, for being with us today. And thank you, Mike, for your service on the World Trade Center Utah board. We really do appreciate it. This was fantastic. It made me wonder, maybe we should do COVID Fridays with Parsons, Behle, and Latimer on the World Trade Center Utah YouTube channel. So we'll follow up with you to get another one of these scheduled on another topic that you are hearing from your clients. And then again, for everybody listening in, thank you for being with us this morning. Please let us know what topics are important to you. We'll go to work and ensure that we're able to deliver that substance to help you and your businesses cope with these unprecedented times. It struck me as I was listening to this that the way we move forward, the way that we adapt, innovate, and overcome is by rallying together. And partnerships and teamwork as a business community are more important now than ever. And that's why we're so grateful to Parsons Behle Latimer for sharing their expertise, for partnering with us today. This concludes today's webinar. Two final housekeeping notes. Please, when you see that survey link pop up, take 2 or 3 minutes. Let us know how we can be better and help your companies more. And then also, if you haven't yet, please go to WTCutah.com. There's a link there. You can sign up to get on our email list and keep an eye out for invitations to future webinars and the other grants, programs, and services that we're providing to companies as we all move forward together. So again, thank you and have a great Friday. Bye-bye.
Thank you, Miles.
Thanks, Miles.
Thank you, everyone.